Attorney General, and we are here to announce an important legal action that my office is taking against the Trump administration. It is our 49th lawsuit in 46 weeks, and it is to protect California's ability to provide critical services to every community, to protect our innovation, and to protect our economy. So today we are announcing that California is leading a coalition of 19 states in suing the Trump administration over its unlawful new policy imposing a $100,000 fee on new H-1B visa petitions. H-1B visas allow U.S. employers, including our schools, hospitals, universities, research institutions, to hire highly skilled workers like physicians, like nurses, like teachers, and researchers. California, like every other state in this country, needs more teachers, more nurses, more doctors. There is a shortage of supply in those professions, and we need more. And H-1B visas have allowed states to provide these essential services despite labor shortages in these critical fields. These workers fill essential roles that keep California running, moving forward. In many cases, they're the backbone of services our communities rely on every single day. President Trump's $100,000 fee isn't just misguided, it is, yes, illegal. And it threatens to worsen already severe labor shortages across California. So we're suing, and we're not going to let that happen. Under the Trump administration's directive, employers filing a new H-1B petition would be forced to pay an unprecedented $100,000 surcharge. This was implemented by the Department of Homeland Security, or DHS, without authorization from Congress, without the legally required notice and comment process, and in direct violation of the law. This massive fee exceeds the Department of Homeland Security's authority. It ignores Congress's careful framework for setting visa fees. It undermines the purpose of the H-1B program, and it grants the Secretary of Homeland Security sweeping discretion to apply the fee selectively. Typically, employers expect to pay between about $900 and $7,500 in fees. These are cost recovery fees, fees that reflect actual processing costs, as is required by the law. The Trump administration's $100,000 charge has no legal basis and no rational connection to the cost of administering the program. It's an unnecessary obstacle designed to shut out the skilled workers America needs and America depends on. The consequences for California would be devastating. We're already facing a nationwide teacher shortage. Last school year, 74% of U.S. school districts struggled to fill open positions, especially in areas like special education, foreign language, and STEM fields. Nearly 30,000 educators nationwide hold H-1B visas, and hundreds of colleges and universities rely on them to support instruction and to support research. Public schools, many of which operate on very tight budgets, can't absorb an extra $100,000 per hire. California's public universities, including our CSUs and our UCs, would also be forced to pay the price for this unlawful policy. A six-figure fee for each hire means fewer teachers in classrooms, fewer counselors and specialists for students, and a direct hit to the quality of education across the state. The healthcare sector is equally at risk. Nearly 17,000 H-1B visas went to health professionals last year, about half to physicians and to surgeons. These shortages are especially severe in rural communities, where access to primary care and specialists is already extremely limited. In certain parts of rural California, a single physician may be serving thousands of residents, thousands of patients. If hospitals and clinics must either pay an extra $100,000 per doctor or leave positions unfilled, the consequences are clear. Fewer providers, longer wait times, reduced access to care, and growing health disparities. And these impacts extend beyond medicine and beyond education. Researchers, engineers, scientists, and public sector professionals who drive innovation and support California's economy would all be harder to hire, or impossible to hire, under this unlawful fee. California can't maintain world-class schools, cutting-edge research institutions, or accessible healthcare facilities if we cannot staff them, which is why we're here today. Congress created the H-1B program over 70 years ago to help employers meet critical labor needs while protecting American workers. It's there for a reason. Unlike these excessive fees, the program isn't baseless. Over decades, Congress has refined this program, setting caps, establishing fees, enhancing enforcement, and strengthening protections. But what Congress has never done is authorize a president to impose a six-figure surcharge designed to dismantle the program entirely. The bottom line is, no presidential administration can rewrite immigration law. No president can destabilize our schools, our hospitals, and universities on a whim. And no president can ignore the co-equal branch of government of Congress, ignore the Constitution, or ignore the law. We're taking the Trump administration to court for the 49th time to stop this unlawful fee and protect the services Californians depend on. California will always stand up when federal actions threaten our people and our institutions. We'll keep protecting our students, our patients, our rural communities already struggling to recruit essential workers, and we'll protect our ability to deliver the world-class education, healthcare, public services that make our state strong. I'd like to take a moment to thank my outstanding team leading this work that got us to this point today: Jimmy Richardson, Denise Levy, Lorraine Lopez, Janelli Orozco Alcala, Aaron Lowe, Marissa Maloof, James Stanley, and Michael Newman. A great team doing great work on behalf of California. Thank you, and with that, I'm happy to take any questions you might have.